welcome to Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Ntina Tzouvala. I work at UNSW as an associate professor. And today I'm joined by Dr. Maria O'Sullivan, who is an associate professor at Deakin Law School. Maria's work has influenced case law, law reform, and public debate. Her research has been cited in a judgment in the High Court of Australia, by the Advocate General of the Court of Justice of the European Union, and in numerous reports of parliamentary inquiries and law reform commissions in Australia. She's currently working on a series of projects related to automation, artificial intelligence, and government decision-making, and she's also conducting research on the law of protest. And indeed, this is why we have invited her here today. But before we get into the substance of it, and since this is this podcast, I must ask our first traditional question. Maria, what is your drink of choice for this morning?
Well, I am having a water because it's 10 a.m., but of course I love my coffee. I've got a fantastic coffee machine that because I love my Americano, but in terms of other drinks, my go-to is Gamay, which is my new perfect red wine for
Oh,
those who can't
wow.
afford, the expensive French Pinot Noir. Go the Gamay. It's my new favorite red wine.
That's an excellent tip. I am also have to say, as you said, it's 10 a.m. and I'm also having water. So we came a bit boring today. Uh, Maria, since you're a new guest here of the pod, I was wondering, and that's a traditional question we ask everyone, if you can tell us a little bit about your career trajectory, including how you found international law, how you ended up working in the vicinity of international law.
Yeah, it's a great question. I guess I've always been interested in the United Nations, but the first real, I guess, interaction was at ANU, Australian National University, and I was taught by Deborah Cass, who some of your listeners will know was an excellent international human rights lawyer, and she taught me international human rights law. So that's where I really thought, okay, I love this and I get it. And then I was very fortunate to do the LLM at University of Essex in the early 2000s, and that's when Nigel Rodley, who was then the UN Special Rapporteur, was there, UN Special Rapporteur on Torture, Professor Kevin Boyle, who was amazing. He had worked tirelessly on human rights issues in Northern Ireland. And there were other scholars who had, in addition to great knowledge of the area, had very interesting, relevant experience. So, Nigel would come back from a country visit, and tell us all about it. And then I guess more recently, when I was at Monash, I'm not at Deakin, but I was around 20 years at Monash, and I worked with the fabulous Sarah Joseph, who listeners will know was the co-author of the leading text, I think, on the International Covenant on Civil and Political Rights. And she's just awesome. And if anyone wants to, I guess, read something that brings public and international human rights law to life, I'd recommend Sarah's great piece on free speech and the cancellation of Roseanne, but many years ago. But it's a go-to piece for those who want to translate international law to media and the public. And I mention that because that's the best example of Sarah Joseph being authentic and unafraid to state her views. So that's, I guess, my trajectory. But I've loved every minute of it.
Yeah, no, I'm not surprised with such incredible teachers and interlocutors and colleagues that that's where you landed. So, as I have said already, Maria is a leading expert on the right to protest under both international law and domestic law. And indeed, very recently, she co-edited alongside Azadeh Dastiari the very recently published International Law and the Regulation of Protest. I will drop a link under this pod for those of you who want to order it for your libraries. And I think you should order it for your libraries because it is a very timely work. As we will discuss in this episode, the right to protest it is under attack around the world. Protesters face escalating, often lethal violence by state authority, as we observed recently in Iran and also in the United States. And even when state repression and violence does not, go all the way to casualties, to causing casualties, states across the world have adopted increasingly restrictive legislation. They have demonized protesters and they have resorted to excessive, even when not lethal, police violence. In light of this concerning trend, Maria, I was wondering if you could tell us a little bit more about how international law both protects and regulates the right to protest.
Sure. I guess I'll start off with the International Covenant on Civil and Political Rights from 1966. Many states are signatories to that. I will get to the domestic application afterwards, which I think is where the problems arise. So, the International Covenant, I'll call it the ICCPR. I know you've got international lawyers here, and then some of your listeners may not know so much about the human rights aspects as such. So yeah, the ICCPR doesn't protect the right to protest as such. It protects freedom of expression and then the right to peaceful assembly. So the article I'm going to talk about is Article 21, which protects the right to peaceful assembly. And I can talk later about what we mean by peaceful assembly. So Article 21 does protect the right to peaceful assembly, but then it's got the normal sort of restrictions that you find in the ICCPR that relates to national security, public order, public safety, and then there's, public health and morals and the rights of others. So, of course, there's a recognition that the right to protest is important, but states can utilize those restrictive elements to say, well, we're going to restrict it on the grounds of public safety. And I really speak to that, I guess, because in Australia, the restrictions that have taken place are either about national security or public order. So that's the article. And in Australia, I guess, as an example, we don't have a Commonwealth Bill of Rights, but we do have the protections in three jurisdictions, Queensland, uh, Victoria, where I'm speaking from, and the ACT, where that's domestically implemented. But just going back to the international sphere, I wanted to talk about two treaty-related bodies, so the UN bodies that are relevant. So the UN Human Rights Committee, which oversees the ICCPR, released a fantastic general comment. So it's General Comment 37 in 2020, and that's a fantastic general comment which elucidates some of the debating and debatable issues. So that includes what is peaceful, when does a peaceful assembly turn violent, the use of protest permits, which are a big thing in my jurisdiction, and also the use of force, which you touched upon. So that's great. The UN Human Rights Committee General Comment is great, but I would just flag that it's difficult to domestically implement that, either in a Bill of Rights, because, for example, in Australia, we don't have that, or in litigation, it's unusual to be able to refer to that. Now, the only exception is that we can use general comments if a UN special rapporteur gets leave to intervene. And the current UN special rapporteur on counterterrorism and human rights, Ben Saul, has successfully intervened in the Palestine, or did successfully intervene in the Palestine action. When I say successfully, he was allowed to lodge an intervention. And we can talk later, if you like, about the extent to which they are referenced in court judgments. And then, speaking of UN Special Rapporteurs, in addition to the UN Human Rights Committee, we do have a UN Special Rapporteur on peaceful assembly, and then also the ones that I mentioned before, torture and counterterrorism. The UN Special Rapporteur on Peaceful Assembly did a fantastic policy brief slash paper a couple of years ago on stigmatizing narratives. And I'd recommend it to your listeners who want to understand this issue more because there's, I guess, legal legitimacy and strength in having the ICCPR protect peaceful assembly, in having the UN Human Rights Committee have this fantastic general comment. But in the end, a lot of what we're talking about comes down to what magistrates do in relation to protest charges, and it comes down to narratives that are entered into by politicians and the media. So I'd recommend that stigmatizing narrative report because it really goes to that issue about how international law is implemented in practice.
That's terrific. Yes. And of course, listeners who are outside Australia, they will have their own experiences about how responsive international domestic courts are to international law. But I think this your account says a lot about how hard it is to effectively raise international human rights law arguments in front of domestic Australian courts. Um, so, a notable trend across jurisdictions, I would say the last few years, is the conflation between disruptive protest on the one hand and violent protest on the other. The conflation happening by state authorities and the effort to heavily restrict or outright ban and criminalize the former, right? And I would say this trend, and you have written about that, is particularly notable in the case of climate change related public action, such as that undertaking by groups such as Extinction Rebellion, right? I was wondering if you could give us a little bit of an overview of the state initiatives, and also you can give us an overview of what, if anything, international law has to say about disruptive protest, right? Protest that like causes problems, but it's not violent.
Yeah, again, my starting point would be the UN General Comment number 37 on peaceful assembly. And that explicitly says that when it's talking about violence, that disruptive protest does not equate to violence. Therefore, I guess the first step, when we're looking at protest is it peaceful and therefore protected by international law? So it's interesting in the general comment, it says that protest which disrupts vehicles or pedestrian traffic, so prevents people from accessing daily activities. So, a protest that's going down a thoroughfare, either a motorway or a street, that will not definitionally bring the protest into the realm of violence. Now, of course, we have those restrictions that I mentioned that are referred to in Article 21 of the ICCPR, which talks about public order. So that's where disruption comes in because under what we call public order or summary offences legislation that is prevalent in most jurisdictions around the world to a varying extent, police can say, well, you're committing a public order offence, so you're obstructing traffic. So, going to the issue of climate protests, this has come up particularly in America, Canada, etc., the UK, and Australia, where climate protesters in particular are seen as disrupting not so much vehicle access or pedestrian access, but mining companies. So, I can speak a lot to that, but one issue is the extent to which economic interests of a country can be affected by climate protest. And I can speak, to the power of lobbyists, particularly here in Australia. I think that is
Absolutely.
also very prevalent in other jurisdictions. And so restrictive laws have been put in place in Canada, in the United States, and particularly here in Australia and in the UK. Things like prevention of what we call tunnelling in the UK. So, tunnelling being a form of disrupting mining or other climate producing or climate change producing activities. In Australia, we've had problems with protesters being unable to protest at logging sites where they want to get footage. And this is where I'd probably talk about the expressive nature of protest. So you can say, okay, well, you can't protest 2 kilometres from a mining site, but protesters for climate change will want to get footage of that in order to affect change and put pressure, quite rightly, on governments to increase their climate or improve their climate change policies. So I would say that there's, I guess, ordinary protests which might occur on a street, and there's debates about the extent to which that can be disruptive, and the general comment's clear on that. I guess the not less clear, but the more debated issue is in the environmental space.
Fair enough. Yes. So basically, the governments seem to like have a general affirmation of the right to protest, but not in a way necessarily that would make it like meaningful or visible. It's like, of course, you can go and protest somewhere where nobody sees you, but that, as you say, misses the point, right? Which is it protest by definition has a communicative aspect, and you need to be able to be visible to meaningfully exercise the right. And if in order to be not disruptive at all, you cannot be meaningfully visible most of the times, at least. Yeah, it becomes a very theoretical exercise of a right. So something that you alluded to earlier was the case of the proscription of Palestine action in the UK. And this is a very interesting case because I think it is indicative of a broader effort of states to classify protesters as terrorists, both in order, as you were saying before, to delegitimize and to stigmatize them, but also more practically in order to apply the draconian and highly discretionary powers that counterterrorism laws have given states, especially since 9/11. Can you talk to us about Palestine action and its proscription, including the very recent decision by the UN High Court that seems to question the extent of the state's discretion to do so?
Yeah, I want to start with talking about property damage. So, property damage may be seen as bringing someone outside the protection of Article 21 of the ICCPR for it's serious, but it's also been used in the terrorism space. So, listeners may know that the UK terrorism law is regarded as overly broad because it encompasses property damage, significant property damage. Other jurisdictions don't have that. Now, obviously, if the property damage is directed at harming people, it brings it into the realm of terrorism law, but significant property damage of itself is problematic, in my view, as a means of bringing a protester or anyone else into the realm of terrorism law. So that's what happened with Palestine Action. There was property damage in an airfield, on a plane, and that was sufficient in the government's eyes to bring Palestine Action within the realm of terrorism law. I haven't looked at the court decision in depth. I do know that it was one on quite a niche public law issue about the way in which the particular minister viewed and considered the relevant policy. But I can speak, I think, to the grounds on which Palestine Action was prescribed. And so, as I said, and I think Professor Ben Saul, the UN Counterterrorism and Human Rights Special Rapporteur, intervened in that case, and people can view that if you just Google that. And I think he and other scholars like myself are agreed that it's an overreach to use significant property damage to not only bring those activists into the terrorism space, but to then prescribe everyone that's advocating for Palestine Action within a terrorist designation. And I guess there's two things happening there. There's the use of terrorism law, and then there's the public commentary on that. Sort of, I guess, about anyone who supports Palestine action being pro-terrorism, and then the footage that everyone would have seen with police arresting thousands and thousands of people just on the basis that they were holding placards saying, I support Palestine action. So that's Palestine action, and it's very important for other jurisdictions, particularly in Australia. And we're going to speak to that, I know, in a moment. But we had the anti-Semitic attack in Bondi, in Sydney in December 2025. And now there's increasing use of hate speech and terrorism designations here in Australia in order to do the same sort of thing, to prescribe protest groups, which is problematic on many levels, but mostly because you are categorizing one particular group as a terrorist or hate speech group and therefore preventing any sort of protest on that issue.
Yes, that's right. Okay. So basically what you're saying is that the prescription in the UK had this like knock-on effect that didn't just target the particular actions, like because basically for those of you who don't know, Palestine action engages in direct action, right? But what it happened is it didn't just empower the state to stop that, which the state could always do, but it empowered them to stop the peaceful protest of others in support of Palestine action, because then you're suddenly advocating for what the state considers to be a terrorist group, right? So it potentially creates an unlimited power for the state to restrict the right to protest of thousands. And my question here is, we have been talking about international human rights law, right? In a sense, as the good guy of the story, because in a sense, General Comment says all these great things, the state doesn't implement them. But I'm wondering if in this example we can see also a little bit a darker side of international law, right? Because international law has been so central in the creation and in the legitimization of these extremely expansive counterterrorism legal architecture across the world. And I would say also, through things like references to public order or national security that historically have been interpreted in very statist and discretionary terms, even by many human rights bodies. I'm wondering if international law, in a sense, is a co-culprit here in this assault against the right to protest. If it has in some ways enabled states to restrict the right to protest, or am I being a little bit too much of a critic and a hater?
Well, I'm not sure about that. I'm not sure about international law as such. And of course, I'm an international human rights law person, which I think may be different to international. That is, I might be a little more Pollyanna, perhaps. So you'll have to excuse me. But look, I can say I think that the under-resourced nature of the system, the UN system, is a problem. So I mentioned these UN special rapporteurs doing really great work. They, for the most part, are self-funded, and say for the most part because they can get donations from countries to assist, and they can get donations from their host country. So, for example, Ben Saul, who's in Sydney, could get funding from his own university, but they are not paid as such. So I think there's a debate going on at the moment about the resourcing of UN special rapporteurs. And then also not so much in terms of critiquing international law, but going back to what I mentioned at the start about the various ways it's implemented domestically. So Australia just went through consideration under the UPR, the Universal Periodic Review. And look, to be honest, I'm not exactly sure to the extent to which Australia takes notice of that. I've done 15 years in refugee law, and I'll be honest with you, I don't think Australia really gives a damn about what the UN says, particularly in things that affect national sovereignty, like refugees. So that's a long-winded answer to say I think it's not so much international law as such, but the way in which the respect for international law is problematic.
That makes sense. Thank you. I think that's one of the things where like my more critical instincts come out. So as you implied earlier, this well, as we you have been talking actually throughout, this question is of particular importance to Australia, right? I'm recording this episode from Sydney, the land, I'm on the land of the Gadigal people, where roughly a month ago, on the 9th of February 2026, thousands gathered to protest the visit of Israel's President Isaac Herzog. The protests took place under the new laws that, as you said earlier, New South Wales introduced after last year's anti-Semitic attack in Bondi, and it was accompanied by extensive state violence, all in the name of social cohesion, right? Many of our listeners might not be based in Australia, so I was wondering if you could briefly outline for us NSW's protest laws, New South Wales protest laws, and what exactly makes them so restrictive and perhaps even problematic under international human rights law.
Yeah, and to start, I guess I want to go back a few years. We've had increasing protest restrictions. Australia is a land of mining. And so I want to talk a little bit about this before I get on to the post-Bondi situation, because it goes, I guess, to the issue of how protesters are viewed in Australia, and it might feed in, I guess, to the police response too. So maybe 5 or 6 years ago, you could see a real shift in the discussion of protest and then changes in states. So Australia is a federation, so we have states and territories as well as the federal government. So the states and territories are important because that's where I guess most of the restrictions with public obstruction of traffic and then the local police operate. So because we are a mining country, we've had use of what's called critical infrastructure legislation, which is not actually terrorist legislation, but it's securitization of protests. By that, I mean it doesn't come out and say climate protesters are eco-terrorists, but basically that's the vibe. So we've had increased sentences for climate protesters, bans on the use of attachment devices, when people want to attach themselves to certain areas of mining sites. And we had quite an infamous arrest and charge of a climate protester called Violet Coco, who was charged with obstructing an ambulance. That was a false charge. So, but overall, there's been a real, attempted shutdown of climate protests in Australia. And I mention critical infrastructure because that comes from the United States, where they've attempted to do the same thing to quite severely increase the sentences meted out to climate protesters. And in America, they've changed them to felony charges. And I mention that because I think there's quite an interesting cross-contamination, if you like, between jurisdictions. You can see that with Palestine Action. Australia has looked at that as an example, and we've also looked with climate protesters at the US. So again, it's, I guess, that second level of how international law might be restricted by the way countries copy each other. So moving to, I guess, the post-Bondi situation, one interesting example of how counterterrorism operates domestically is in the wake of Bondi, the New South Wales government amended the New South Wales terrorism laws to allow what is called public assembly restriction declarations. So that's a, somewhat fancy or long-winded word for saying that protest under this terrorism law can be declared, or protest areas can be declared to be unauthorised areas. So just stepping back, in New South Wales, where Sydney is, terrorism issue was that post-Bondi, the New South Wales terrorism legislation was changed to introduce what is called public assembly restriction declarations. And to step back a bit, in New South Wales, in order to protest, protesters have to give notice to police with 7 days' notice and get what's called an authorised protest. So what these public assembly restriction declarations did was say that in the central part of Sydney and the so-called eastern suburbs, so a little bit outside, people couldn't get authorised protests. And that's a big, big issue because it has a chilling effect on protest if people can't get authorization from the police. And it also meant that police had extraordinary move on powers, the ability to find people when they wouldn't, and then also warrantless searches. So that's one layer, this public assembly restriction declaration. And about three or four of those were made. In its first iteration, the declaration included all of central Sydney and a little bit of the suburbs. And then in the third or fourth one had a carve out for what's called Hyde Park, a park in the centre of Sydney, which has a little bit of thoroughfare, so it has a bit of public activity, but it's a little bit away from the main areas of protest. And I mention that because it goes to that communicative aspect of protest. So that's the first layer. And the second layer was something that happened for 4 days during President Herzog's visit, and that's a major event declaration. That was challenged in court, but unsuccessfully, again, for a very niche public law, admin law issue. But that allowed, again, extraordinary powers given to the police to move on protesters if they didn't comply with directions. Now, sometimes police had those powers, but these were extraordinary powers in this instance. So we have these two layers of declarations which occurred during those protests that you speak of, Nina, and I guess there's an argument that that really led to the police brutality that we saw in Sydney recently.
Great. Okay. Well, not exactly great, but this was a very helpful explanation of like where the additional restrictions lie. I think like substantively we're done, Maria, but one final question that we like asking everyone is to tell us at the moment whether there is something that helps you unwind and take your mind away from international law and also the seeming collapse of the international order.
Well, I'm a bit of a fashion tragic. So I spent the
Ooh.
weekend with my girlfriends going to Gimlet in Melbourne, a really nice restaurant. We dressed up in vintage and went to the Vivienne Westwood exhibition in
Oh, that
Melbourne.
sounds
So,
amazing.
and I love looking at the red carpet at the Oscars. So,
And that's
yeah,
the season for it, isn't it?
yeah.
That's really red carpet season. Okay, that is definitely a much more upbeat note to what we have been talking about. Thank you very much. And we will also drop links to your book, but also to other resources that you mentioned in case our listeners want to find out more. Thank you so much.
Thank you so much, Nina.